Okay. Good morning, good afternoon, good evening. Again, depending on the time of the day that you're taking time to listen to our lecture series on corporation law. So this will now be part 9 of our RFB Corpo lecture series. And our topic for this particular presentation will be about mergers and acquisitions. Take note that this topic on mergers and acquisitions is also applicable not only to stock corporations but also to non-stock corporations. Be that as it may, let's first talk about the key rules and laws which are relevant to the discussion of mergers and acquisitions. Okay, so on the question of what are the key rules, laws relevant to M&As, okay, and what are the key regulatory authorities on the matter, okay, we have this particular laws, general law and special laws on the matter. So we have the Corporation Code, which is considered to be the general law on corporations and M&As in the Philippines. We have the SRC, or the Securities Regulations Code. Okay, so you have been given already a handout on the matter. I would try to actually incorporate a particular topic on SRC as we are now talking about M&As. Okay? So the SRC imposes additional requirements for M&As involving listed companies for the protection of stockholders. So it has a special application and it finds application to listed companies for the purpose of protecting them. Okay, stockholders, okay, shareholders of these listed companies. Another special law is actually we have the Foreign Investment Act of 1991, as well as other certain provisions of the Philippine Constitution and other laws that that actually attempts to impose foreign ownership limits in certain Philippine industries. Okay, I will be referring you again to your Corpo handout, part 1, where you actually see their listing in relation to the latest in L. Okay, we also have the Philippine Competition Act, which is a relatively recent legislation requiring merger clearances prior to the consummation or the implementation of the M&As. Okay. The SEC is the national government regulatory agency that implements the Corporation Code, the SRC, as well as the foreign ownership limits under the Foreign Investments Act through its regulatory power over all corporations. Regulated or nationalized industries under FIA, Foreign Investment Act, are defined by the Office of the President through the promulgation of the FIN-L, okay, the Foreign Investments Negative Lists. Under the most recent FIN-L of 2018, okay, as we could be recalling, as also mentioned in your handout, internet businesses can now have 100% foreign equity ownership. What more? Contracts for construction and repair of locally funded public works now have what? A 4% foreign equity cap, maximum foreign equity cap, which was previously set at 25%. So medyo naging liberal po tayo and we give a foreign equity 40% from the previous 25%. What more? Okay. Still, in relation to the latest FIN-L, 11th FIN-L, insurance adjustment companies, lending companies, we have financing companies, and investment houses were delisted, meaning, okay, we can now allow foreign equity ownership 100%, okay, in these types of companies. So the Philippine Competition Commission, PCC, is the regulatory and the quasi-judicial agency that is tasked to implement the PCA. Okay. The primary function of the PCC is to review and to clear M&As which meet, first, the size of party, second, the size of transaction thresholds. So these are active special rules that are now imposed under our law. It also has jurisdiction to hear and to decide cases involving the validity of M&As and penalizes anti-competitive acts such as the abuse of dominant position. We have bid rigging, we have price fixing. So all these are actually found under the provision of the PCA. So I guess you are lucky that it's still not yet part of your syllabus, but maybe okay, come the next syllabus, SIPALI syllabus, which I think will take effect 2022. Okay, I'm actually expecting okay that the PCA will now be added. Okay, so other than these four listed laws, okay, the BIR also plays a part in M&As through the issuances of tax clearances that are necessary for the transfer of shares and other assets to the acquirer. Okay, so M&As involving regulated industries usually require also the endorsement or the approval of certain government agencies. For example, okay, M&As, mergers and acquisition involving banks, require the prior approval of BSP, Bangko Sentral ng Pilipinas, and is subject to the rules and procedures contained in BSP's Manual of Regulations for Banks, which we also know as MORB. Okay, so this is just a prelude to your learnings on banking laws, which is also a special law that is now covered by CIPAL syllabus. So let's move on. The next question is, what are the key means of effecting the acquisition of a publicly traded company? Okay, so to enumerate, we have here share purchase. It could either be asset purchase, or if not, okay, via the statutory mergers and consolidations, which are actually discussed in the general law, the revised corporation code now. Okay, so generally, acquisitions are structured as share purchases. Okay, for what reason? For tax efficiency and simplicity. So you simply buy shares. So this is one way by which one becomes a shareholder for our most per the last discussion on stockholders. Okay. Or we also have here asset purchase. So contracting parties may also choose to utilize an asset purchase when the acquirer, okay, so meaning the purchaser or the buyer, seeks to obtain only a portion of the assets of the target company, or where there are risks, there are obligations and accountabilities of the target company which the acquirer does not want to assume. So we take a look at when could it be considered a share purchase, when is it an asset purchase. Okay, so asset purchase, technically it will depend upon the intention of the acquirer or the purchaser. If the acquirer or the purchaser would wish, okay, not to assume all of the liabilities that goes with acquisition, then asset purchase can be had. So a publicly listed company can likewise be acquired through the statutory mergers and consolidations. Okay, so which we will now be discussing. So we have here the definition of merger and consolidation, which we actually see from the provision of the law. A merger involves a business combination whereby two or more corporations merge into a single corporation, which will be one of the constituent corporations. If from your accounting subjects, you know that if we are to translate it in a formula, merger can actually be phrased as A plus B, okay, is equal to either A or either B. So merger. What about consolidation? On the other hand, it involves a business combination whereby two or more corporations consolidate into a new single corporation, which shall be now the consolidated corporation. Ito yung alam natin na A plus B is equal. Yes? Yan, the business combination. So moving on, let us see, okay, what again the RCC expressly provides on the matter of plan of mergers and plan of consolidations. Okay, let's hear it from the law.
Section 75 of the RCC on plan of merger or consolidation. Two or more corporations may merge into a single corporation, which shall be one of the constituent corporations, or may consolidate into a new single corporation, which shall be the consolidated corporation. The board of directors or trustees of each corporation, party to the merger or consolidation, shall approve a plan of merger or consolidation, setting forth the following. A. The names of the corporations proposing to merge or consolidate, hereinafter referred to as the constituent corporations. B. The terms of the merger or consolidation, and the mode of carrying the same into effect. C. A statement of the changes, if any, in the articles of incorporation of the surviving corporation in case of merger, and, in case of consolidation, all the statements required to be set forth in the articles of incorporation for corporations organized under the Code, and D. Such other provisions with respect to the proposed merger or consolidation, as are deemed necessary or desirable. Section 76 of the RCC on stockholders or members' approval. Upon approval, by a majority vote of each of the board of directors or trustees of the constituent corporations, of the plan of merger or consolidation, the same shall be submitted, for approval by the stockholders or members, of each of such corporations, at separate corporate meetings duly called for the purpose. Notice of such meetings shall be given to all stockholders or members of the respective corporations, in the same manner as giving notice of regular or special meetings under Section 49 of the Code. The notice shall state the purpose of the meeting and include a copy, or a summary, of the plan of merger or consolidation. The affirmative vote of stockholders representing at least 2/3 of the outstanding capital stock of each corporation, in the case of stock corporations, or at least 2/3 of the members, in the case of non-stock corporations, shall be necessary for the approval of such plan. Any dissenting stockholder may exercise the right of appraisal in accordance with the Code, provided that if after the approval by the stockholders of such plan, the board of directors decides to abandon the plan, the right of appraisal shall be extinguished. Any amendment to the plan of merger or consolidation may be made, provided that such amendment is approved by a majority vote of the respective boards of directors or trustees of all the constituent corporations, and ratified by the affirmative vote of stockholders representing at least 2/3 of the outstanding capital stock or 2/3 of the members of each of the constituent corporations. Such plan, together with any amendment, shall be considered as the agreement of merger or consolidation.
Okay, that is what we mean by a plan of merger or a plan of consolidation. But then again, it doesn't end with plans, yes?
Section 7.
Let us continue with what, again, the RCC would provide on certain procedures